775.084 statute. One of those officials was Leticia J. Marquez. On October 10, 2016, Leticia J. Marquez summed up Michael Rigby's entitlement to a new sentence as being based on nothing more than a mere technicality. Marquez's loose use of the word technicality leads the pro se defendant to fear that he will not receive a fair sentencing based on the fact that the statement appears to commit Marquez to the biased mentality that the defendant's appearance for resentencing is the result of his own capitalization on a technicality and not based on the violation of his constitutional right to due process of law via the imposition of the court's erroneous illegal sentence. By making such a statement, Marquez has violated Canon 3, Section E, 1F, 2, and 3 of the Judicial Code of Conduct, which states, E. Disqualification. 1. A judge shall disqualify herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where F. The judge, while a judge, has made a public statement that appears to commit the judge with respect to 2. In issuing the proceeding, or 3. The controversy in the proceeding. The defendant has a mental disability and has undergone 9 mental evaluations by order of the court. Marquez is well aware of the defendant's mental disability. On October 10, 2016, Leticia J. Marquez showed conduct which manifested an apparent bias to the defendant's disability when she expressed frustration and overwhelming stress by grabbing the top of her head with both of her hands and vigorously rubbing her hands back and forth through her hair while breathing loudly, rudely, and unprofessionally during the defendant's humble vocalization of his interest in the court appointing an expert witness to detail the defendant's state of mind during the commission of the crime. The commentary under Canon 2A states, quote, a judge must expect to be the subject of constant public scrutiny. A judge must therefore accept restrictions on the judge's conduct that might be viewed as burdensome by the ordinary citizen, unquote. The commentary under Canon 3B5 states, quote, a judge who manifests bias on any basis in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Facial expression and body language, in addition to oral communication, can give to parties in the proceeding an appearance of judicial bias, unquote. On October 10, 2016, Leticia J. Marquez refused to dispose of a fundamental judicial matter promptly, efficiently, and fairly in blatant disregard to Canon 3B8. Canon 3, quote, a judge shall perform the duties of judicial office impartially and diligently. 8. A judge shall dispose of all judicial matters promptly, efficiently, and fairly. On March 16, 2016, the state filed a notice of its intent to seek an enhanced sentence that would amount to either a violation of double jeopardy or a violation of due process of law via vindictiveness. 208 days later, Marquez still has refused to hear the matter and instead elected to cram the evidentiary hearing into the same day as the sentencing hearing. Marquez has made a blatant, biased, and dangerous decision. In the past, she has exposed incompetence with dealing with the 775.084 statute, whereas she was under the impression that the defendant qualified as a habitual felony offender by, quote, committing a crime while serving the sentence of his only prior conviction, unquote. Marquez denied the defendant's 3.800 motion to correct an illegal sentence that was subsequently found by the 5th District Court of Appeal to accurately direct attention to an illegal sentence that was then reversed and remanded and somehow assigned to Leticia J. Marquez, the same biased judge who initially denied the defendant's request for relief. Marquez has ordered 5 separate competency evaluations on the defendant within the past 5 months, and all reporting doctors have found the defendant competent to proceed. The judge also showed bias by implying that the defendant pled to an escape charge in exchange for a dismissal of an attempted murder case. Her implication reveals that she apparently subscribes to the biased opinion that the defendant only pled guilty to evade more serious charges, when in reality there was no plea deal at all. The defendant was accused of telling a female to shoot another female, but a subsequent investigation proved that the shooter shot the victim in self-defense and then pled guilty to an offer of 7 years. The case was dismissed under the informed about facts that she could have easily discovered through mediocre investigation had she not been so biased that she didn't even bother to double check. I, Michael J. Rigby, the pro se defendant, am honestly afraid that Leticia J. Marquez has formulated a biased opinion of my character, an opinion that she absolutely despises, and based on the false persona of that despicable opinion that is nothing more than a figment of her own prejudiced imagination, I fear that she has ill intentions of imposing a harsh sentence upon me without regard to the fact that I do not deserve it. It has become impossible for Leticia J. Marquez to provide Michael J. Rigby with any form of fair or